Howdy, my name's Daniel Thompson, and I decided to do this video presentation over Kleintech versus Gettysburg. It's basically about this lacrosse player who ended up having cardiac arrest on the field during practice. Drew was a 20-year-old sophomore at Gettysburg College. He was participating in a practice in an off-season routine, which happens every day in pretty much every college across America. They stretched, they did a few drills, they did everything, day-to-day operations that every college program goes through. They then decided to do a 6-on-6 drill. Drew was a part of one of these drills when he kind of walked off to the side, kind of took a knee, fell down. A couple of his teammates realized something was wrong, and that's when he had his first cardiac arrest that ultimately ended in his death. The head athletic trainer got there after he was phoned by an assistant athletic trainer who couldn't really figure out what the problem was. The head athletic trainer got there, tried to resuscitate him, CPR, standard procedure, everything that he knew to do. An ambulance arrived, took him to the hospital. They did everything in their power to resuscitate him, but shortly after he was pronounced dead. Drew was the type of kid who was relatively healthy. His family, the plaintiffs, described him as healthy, physically active, and vigorously young, with no unusual medical conditions. This was just something that came out of the blue. The tragic event that took the life of a student athlete, and the parents decided to pursue legal action against the college for this risk management type of lawsuit. They have to provide burden of proof of neglect among the college, which therefore the college, the defendant, has to provide their burden of proof that they did everything by the book to their knowledge so that they're not held liable for the student athlete's death. From my reading and a little bit of other research I did online, in order to have this claim of negligence upon the College of Gettysburg, the plaintiff must be able to prove all 5 things. There must have been a duty, a breach of duty, a casual connection through factual cause of damages, an establishment scope of liability, and the proof of physical and or emotional damages. So in the plaintiff's mind, they feel like there was a duty by the college. The breach of duty occurred when they didn't recognize this illness in their son Drew. They felt that had a proper physical, other signs that Drew was fatigued, could have prevented his death at the least. They also feel like the scope of liability relies on the college because he was in their care, he was in their athletic facilities, he was at their will. And then their proof of physical or emotional damages, their child died, and so they feel like the college should be held responsible for his death. The school had actually just hired 2 full-time athletic trainers in 1988, the year that Drew suffered this incident. Joseph Denali and Garth Beiser. They were both board certified by the National Athletic Trainers Association, which meant they had covered all of their training, all of their expertise in their field of athletic training was covered. That included CPR. So it's important to know that Joseph Denali, the head trainer that showed up upon the student trainer's request that performed the CPR, was fully certified in what he was doing. So the biggest argument that the Kleintech's parents were arguing for the case of their son Drew was that the college owed its duty to Drew because he was a student athlete. There was a special relationship there that the college should always be aware, especially in a contact sport like lacrosse, that there's a risk for cardiac arrest and or serious death or injury. In the district court, the court agreed with the college that they had done everything right, that although this foreseeable tragic of death is evident, that the college did everything in their power to prevent it. However, in the Third Appellate Circuit at the federal level, the court overturned the district court's decision and all those before it, and sided in favor of the plaintiff, the parents. They said that had there been adequate or sufficient equipment or training, that Drew might not have died that day. The school, Gettysburg, argued that they shouldn't be held liable because Pennsylvania has this thing called the Good Samaritan Law, which means that basically any bystander that tries to help somebody who's dying, for instance, and give them CPR, that any good random person, bystander that tries to help them is immune to any legal action because they were simply just trying to be a good person and help somebody out.